Thank you for joining the Center of Criminology seminar series. My name is Susanna, just in case some of you don't know me, from the Center of Criminology. Thank you for joining us in this seminar series with Sapna, who's a lecturer from the Department of Commercial Law. And also, before I go any further, I would like to give a special welcome to the colleagues from Public Law. Thank you so much for joining us. Just a little bio about Sapna. She graduated from UCT, University of Cape Town, with a BA in History and Psychology with a distinction, and LLB with magna cum laude. And thereafter, she completed her articles of clerkship at ENS Africa's Banking and Finance Department, where she developed a passion and a knack for financial services, mainly for law, sorry. She currently teaches commercial law, transactions law to final year LLB students. She's now completing LLM in public law at UCT with a focus on criminal justice, human rights, sexual offenses law, and has dual expertise in variety of areas of both public and commercial law. And her talk today, which is one of the interesting topics, especially in the South African context, on violence against children. And she'll be looking at the holistic interpretation of the child's right to the protection from violence, and specifically focusing on whether the South African government has adopted and implemented effective measures to eliminate violence against children. And also, she'll be also looking at the Children's Act, number 38, 2005, and also the National Child Care and Protection Policy. And I do not want to waste your time. I mean, you had to come here, your busy schedule. So I would love to give her this opportunity to take you through in this very, I think, very important topic, and offer to you, Sapna.
Thank you, Sisanda, for a warm welcome. And thank you all for attending today. It's good to see all of you. So my research today came out of a research paper I did for my LLM. It was from the course on international rights of the child, which Salona Lachman, who's sitting in the audience, I can see. It was co-convened by Salona and our other colleagues, Nurina Ali and Matabo Base, for the first time this year after a few years break. So my research focuses on holistically interpreting the scope of the children's rights to protection from violence that's contained in the United Nations Convention on the Rights of the Child. And my interests in public law generally goes towards violence against women and children, so gender-based violence. So I thought this was a good opportunity to focus on the protection of children and to find out what rights do they have under the international framework, and then have a look and see how this is implemented at a domestic level by the South African government. So that was sort of why I chose this topic and my interest in the topic. So today I'm just going to start off by speaking about the prevalence of violence against children in South Africa. I think, you know, this is a topic that we're all very familiar with, and it's not really in need of much explanation, but I think that's an important starting point in realizing why these legal rights of the child become so important if we look at our domestic context. And then I will interpret the international law framework and then move on to evaluating the domestic law. So here, I just included two articles that I thought were particularly harrowing, and I don't want to focus on this too much, but UNICEF found that in the period between October to December 2021, that there were 352 child murders in that 90-day period. And as you can see, the headline is 352 child murders in 90 days are 352 too many. And this doesn't even include the 394 other children who survived attempted murders and the 2,048 other children who were victims of physical assault. And that's just mentioning the reported cases of violence against children. So I'm sure there are just far many other cases. So without dwelling on that too much, I thought I'd just talk a bit about the effects, potential effects of violence against children and why it's important that we prevent violence against children. So violence against children has the potential to negatively impact the health, psychological, and social well-being of children, as well as hindering their ability to realize their potential throughout their lifespan. It can potentially cause learning difficulties and problems later in life in relationships and in their jobs or with seeking employment. And specialists in the field of child development have found that adolescence is a critical developmental milestone, as it's the period that separates childhood from adulthood. So they found that if early experiences are marked by violence, there's a higher chance that children and adolescents will then integrate this into the way that they process the world around them. And it's also important to note that there are gender dynamics at play when it comes to violence against children. So violence against children affects both boys and girls, but sexual violence is more prevalent amongst young girls. And research has also found that where young girls experience sexual violence at an early age, this can be a risk factor in facing abuse later on in life. And it's also been found that in some children, experiencing violence early in life can lead to an increased risk of perpetrating violence in future. So that speaks towards sort of cycles of violence and victims potentially becoming perpetrators. So to move on to the legal framework, the United Nations Conventions on the Rights of the Child is a human rights treaty that attempts to give effect to the rights of children. So their civil, political, economic, social, health, and cultural rights. And this treaty speaks to the manner in which that states should then regulate the rights of children and work towards making these rights available to all children. And this was the first legally binding treaty to affirm the rights of children. And this was ratified by the South African government in 1995, and it was the first international treaty that the new South African government ratified. So Article 19 speaks to the child's right to protection from violence, and it speaks to all forms of violence. It includes physical and mental violence, and importantly, it also speaks about abuse and neglect and negligent treatment. So it encompasses quite a broad definition of violence, and it mandates state parties to adopt legislative, administrative, social, and educational measures in order to protect children from violence. And the UNCRC is very clear in that the primary responsibility for protecting children from violence falls on the state and not just parents and other primary caregivers. So it acknowledges the important role that the state needs to play in protecting children from violence. Now, General Comment 13 was enacted by the UN Committee to elaborate on Article 19. So general comments are not binding law, it's soft law, but it interprets the right and sort of gives an opinion on the scope of the right. And here, an explicitly child rights-based approach is adopted. And this is a break from the traditional welfare approach where children were regarded as passive objects in need of parental assistance, as disempowered victims, whereas this child's rights-based approach views children as active subjects who bear rights and should have the ability to participate in decisions that will affect their well-being, development, and their health. So in interpreting the scope of the right to protection of violence, I found that this interacts with other rights contained in the UNCRC. So I focused my interpretation on including the best interests of the child. So the best interests of a child are a primary consideration that needs to be taken into account in all decisions affecting the child, especially if we are considering separating a child from their family. In that case, the best interests of the child outweigh any other competing interests of their parents or caregivers. And the other crucial right that needs to be included in order for protection from violence to be meaningful is the right to be heard and to participate in decision making. And I put participation with a question mark because some commentators have argued that the right to be heard is different from the right to participate, and that it doesn't encompass participation. But I'm of the view that in order for the rights to be heard to be meaningful, participation by children is necessary. And the general comment 13 emphasizes that child participation promotes protection and that child protection is also key to participation. So both impact the other. And the last right that is impacted is the right to life, survival, and development. And of course, if a child experiences violence, this will could negatively impact or remove their right to life. And the right to survival and development are also implicated. And this goes back to what I said earlier about the negative developmental impact that violence can have on children. And because experiencing violence is inherently disempowering, it's important that any child protection measures that are adopted shouldn't disempower children even further. But it's important that they positively support a child's recovery through active and facilitated participation. And this right to development and participation should be considered in all decisions made regarding the child. Research has found that the child's own views should be taken into account, and that it's important to hear how the child experiences, what the child experiences and how they make sense of their own experience. So it's important to acknowledge the resilience of children and not view them simply as victims. So the CRC mandates that domestic legislation be adopted to address protection from violence. And crucially, the CRC makes it clear that legislative measures includes budgeting, implementation, and enforcement measures. And this will become important later, because if there is a lack of implementation and a lack of political buy-in, having rich paper law is meaningless. So it's important that the CRC includes this in the ambit of legislative measures, because it means that if something is just on paper but not being implemented into practice, that international law obligations are not being met. So I had a look at the Children's Act and the National Child Care and Protection Policy, and I evaluated this against the legislative framework and the broad scope of the right that I just set out. And I note that I only evaluated this insofar as it spoke about prevention and early intervention measures. The CRC also mandates that there be reactive measures taken. So once a child has experienced violence, measures should also be taken at that point. So I only focused on prevention, so preventing any violence. The Children's Act was signed into law by the South African government in 2006. And this marked a shift from the welfare approach, which focused more on removing children from their families and removing them from difficult environments, whereas the Children's Act allowed for a new holistic system to be implemented with the aim of empowering families to protect and care for their children. So rather than just disempowering families and focusing on the removal of children. And briefly, I found that while the Children's Act does comply with a lot of the international law obligations, there's a very narrow scope of prevention and early intervention measures that are included in the Children's Act, and that there's a need for more of a focus on childhood development going forward. And there was largely compliance, but this was insufficient in promoting child participation and focusing on their holistic development. Now, the National Child Care and Protection Policy, this is a recent policy document from 2021. And this has a much broader reach than the Children's Act when it comes to protecting children from violence. And that's understandable because the Children's Act doesn't only deal with protection from violence, but it deals with all other rights of the child. So whereas this policy is able to focus just on that right. And the policy has many positives. It acknowledges that children from historically marginalized backgrounds remain vulnerable and face challenges. And this allows for the right of children to non-discrimination, which is protected in the UNCRC, to be given effect to. So it recognizes that any potential factors that may have a discriminatory impact on some children but not others needs to be addressed. The policy has a good wide definition of a child in need of care and protection, and also emphasizes that a child who has been deprived of care or may be at risk of being deprived of care is a child in need of care and protection. So it has a wide ambit of children. It covers a wide ambit of children who need to be protected. It also has a very long list of vulnerable children, and this is not a closed list. So it mentions undocumented children, children who are abused by family members or made to commit crimes by other family members, children of parents who abuse substances. And importantly, it also recognizes the intergenerational cycles of violence that may exist and emphasizes the need to break these. And the two important aspects of the policy, which I found really speak to the holistic interpretation of the right to protection from violence, is an emphasis on community interventions. So not only at a state level, but at a grassroots community level. And it also emphasized the need for child support grants. So child support grants can be important in ensuring that caregivers are able to look after their children, and that in turn protects children. So overall, the policy insofar as it deals with prevention and early intervention measures is commendable. It covers a wide variety of areas. It gives effect to the UNCRC, and it certainly goes further than the Children's Act. But in my evaluation, I emphasize again that it's important for legislative measures to be implemented. It's crucial that there be political buy-in from the state and that the state devotes its time and resources to these issues. So it's insufficient if we have paper-rich law, but this is not being implemented. Some commentators have argued for a child rights adjudicative body, sort of like a child rights ombudsman, or another body that can provide oversight. It's also important that in budgeting decisions, protection from violence and children is emphasized. One of the shortcomings of both the Children's Act and the National Child Care Policy is that it doesn't expressly adopt a gendered view of violence. And we can argue that perhaps this is fine because because the Sexual Offences Act and other legislation does adopt a gendered view, and this also relates to children. But I argue that in order for legislative measures to be impactful or to be effective, it needs to expressly recognize the gender dynamics at play in violence against children. There also needs to be more room for child participation, so in the decisions that affect them, but also in the legislative scheme and any further measures that will be taken to protect children from violence. So that was my evaluation and my recommendations. And in conclusion, any future research should focus also on reactive measures, not just the prevention and early intervention measures. Yeah, thank you.
Thank you so much, Sapna, for such sit down. Okay. Thank you so much for such very interesting. I mean, you said it yourself, this is not something new, it's something that we know about violence against children. And before I give it to the floor to ask questions, but I would like to acknowledge our online audiences, which I forgot to acknowledge. We have 9 people who have joined us online, and questions, they're also welcome to ask questions, and you can just give a comment. You don't have to ask questions, you can just give a comment about the presentation from Sapna. So I think this is the time, if you have any question. You're just looking forward to asking a question. Okay, I'll give it to you right now. If there's another person or Ivan, okay, more questions and comments. Okay, I will start at the back. You can ask a question and give a comment. Thank you.
Sapna, thank you very much for that presentation. I thought it was a really great overview of the policy, within an international context and domestic context as well, and for your own evaluation of the policy. So I have 2 questions, and I must confess the second one is probably a little bit more difficult, because I think we're all still kind of working through it, but I would appreciate your thoughts on it. So the first is, does the policy say anything about conflicting interests and values and rights, when, for example, the rights of parents come into conflict with the rights of children? And I'm thinking, for example, within the context of culture and religion, is there any guidance in the policy about that? We've got some guidance from the Constitutional Court, but that's I would argue, a very specific case, and it addressed conflicting rights within a particular context, and it's possible that if given a different set of circumstances, the court might come to a different understanding. So I was just wondering if the policy has given any indication about those balancing, the balancing of conflicting rights, interests, and values. And then the second question that I have is, we take it so for granted that the Children's Convention, our constitution talks about the best interest of the child being of paramount consideration. But what are the norms and standards that actually inform that principle? And which norms and standards should inform that principle? Because it's very easy to argue from a cultural or religious perspective that the concept of the best interest of the child might mean one thing, and in a different context, it might mean something else. I mean, certainly a Western global North perspective of it might be very different. Yeah, and so I was just wondering if you had if you thought about it and if you have any thoughts about it. Thanks.
Before she answers that question, I think I'll just give someone to ask.
Yeah, I just wanted to ask in terms of when you mentioned the rights of children to be heard and meaningful child participation, what would participation for children look like, but also in a way that doesn't force them, you know, because my only experience in terms of child's rights is in cases of sexual violence and sexual offenses, and I can understand that it has psychological implications to force, you know, children to maybe stand up for themselves when they're not ready to. So I just wanted, in a broader context, what would child participation look like, also in a way that's not detrimental to them? Yeah.
I think if you answer this question at least, yes.
Okay. Yeah, thank you both for your questions. I will answer Wahida's questions first. So, as far as I can remember, the policy does mention, and this goes to your second question, best interest of the child, sort of as the factor that will always sort of decide. It's the decisive factor when there are competing interests at play. The policy is cognizant of our South African context and that there may be cultural rights which differ across cultures and that may impact sort of the relationship between caregivers and children. But I think when it comes to balancing any conflict, it looks at, again, best interests of the children. And again, I think this is where child's right to be heard and participation comes in. So
Can I ask you to speak a little bit louder, please?
oh, sorry.
For the audience online.
Okay. Yes, sure. So off the top of my head, I can't think of any specific sort of wording that the policy uses other than emphasizing the best interests of the children come first. And to go to your second question, definitely best interests of the children, it's sort of a buzzword that's always thrown around, and definitely you know, a Western society, the global north may have a different understanding of the best interests of the child compared to Eastern cultures or Southern societies. So I am very cognizant that best interests of the child is sort of a term that can be rendered meaningless or superfluous if we don't give it content and use it appropriately. But I actually haven't looked into that more, into what appropriate definition of it. Yeah. Okay. Yeah, thank you for your question, Dima. That's a very important topic that you brought up. Children may be forced to then participate in difficult proceedings and sort of be forced to grow up a bit too early. So be forced to do something that they're not, to testify, give evidence when they're not ready to. So when it comes to protection from violence, of course, there's different stages. So if we're looking at adopting legislation, I would argue that children should be heard at that stage. and they should participate at that stage. And again, it would also require, buy-in from children. So not making it compulsory, not forcing children to now participate because, they need to, but rather ensuring for meaningful participation. So where children have something to say, that they can be heard. Yeah. And when it comes to sort of reactive measures or early intervention, then it can become difficult, like you say, because it might be traumatic for a child to then, participate and be heard at that stage. And that's also why protective measures need to be in place at all those stages. So if you think about court proceedings, if a child is giving evidence, there's options there for them to have an intermediary to assist them with testifying, or for them to do this via CCTV cameras and sort of a closed footage. So I think, yeah. And again, it can also differ from child to child. So it's very hard to say, have a definitive, yeah.
Just a second now. I think I should have asked the audience before you ask a question to just tell us your name, give us your name. I'm sorry to Wahidi and Dima for not asking that. To tell us your name and your department, where you're from. Thank you so much. Thank you. Ivan from Criminology.
Thank you. Thank you for that talk, Sapna. I thought it was really thought-provoking and very interesting. Because I don't have a legal background, I just want you to expand upon this notion of the that you put up in your slides for the right of the child to be heard. How do you ensure participation? What is your understanding of participation by the child in that? And then secondly, the policy around child protection measures should not disempower children. Maybe you can share with us what you think about that and how that disempowerment of children could be prevented. What is meant by that? Thanks.
Before she answers that question, do you have any questions, online questions? Okay. Yes, please.
I do, but I have 3, so you can deal with those ones first. Otherwise, I'll overload Sapna.
Yes, you can answer Ivan's question.
Okay, great. I'm just want to read this before I say the wrong thing. Okay, so thanks for your questions. And yes, I recognize that many people don't have a legal background. Yeah, so I tried not to focus too much on the sort of, the hardcore, difficult legal obligations. So the interaction between the right to be heard and the right to participation, the United Nations Conventions on the Rights of the Child specifically includes the right to be heard. And many commentators have interpreted this as including participation. So being heard means a child then, participates in the decision. So not just that, they say something, someone listens to it, and that's the end, but that rather they can have an impact on any decisions that are being taken. But some other commentators have argued that interpreting the right to be heard as including participation sort of waters down the right to be heard, because it's not actually contained in the convention and we're now reading in something that's not there. So the justiciability or the ability to sort of challenge the right to participation isn't so clear cut. So whereas the right to be heard is what's expressly contained. Yeah. So thanks for that. And then, yeah, on not disempowering children, again, that's, you know, that's it's a difficult question to answer. Yeah, like I had mentioned, because violence can inherently disempower children, it's important to try find ways to empower them. So again, I thought participation or inclusion, and ensuring that children have a say in the matters that affect them is one way of ensuring that they are empowered, so that they can feel that they are in control of their own lives, in control of, you know, the rules that will protect them. Yeah.
Thank you so much, Sapna. Yes, sir, you can go ahead.
I'm Simon from private law. So I want to just build on what Wahida mentioned about the best interests of the child, especially in relation to how we define that and the content that we give to it, because the knee-jerk response would be that children often don't know what is in their best interests. And so we default to what the parent thinks is in the best interest. But in the South African context, we so-called have this big daddy, which is the Concord, and the Constitution itself, which proclaims to know what's in the best interests of the child as well. So I wonder how you negotiate those three different parties, with all of them wanting to stake a claim to defining the content of what the best interest of the child is. And the child being upset that the parent has too much say, the parent being upset that the Concord has too much say, and then the Concord being upset that everyone else has a say but them.
And the criminal justice system, right?
Yeah.
Actors in the criminal justice system who also think that they have a say in what's in the best interest of the child.
Yeah. So that's my first question. The second question just relates to your comment that we have very rich paper law, but not enough action on the ground. That is unfortunately quite a generic criticism of South African governance generally, is that we have very good laws, just poor implementation. So I wondered if you'd done any comparative analysis with other countries who have signed and ratified this treaty, and compared their legislative enactments with our Children's Act, or at least the central policy of the government in power, as opposed to our national policy, and whether, even though it is only rich on paper, is it the richest, or could it be better? And then my third question is just in relation to the gender dynamic that you mentioned, and how you feel that the Children's Act itself should have something to say about the gender dynamic of violence against children. Do you mean that exclusively in relation to the victims, or would you also be interested in the Children's Act taking a stance on the gender dynamic of the perpetrators of violence against children, or both? Yeah.
Thanks, Simon. Those are three difficult questions. When it comes to the first one about the best interest of the child, you know, it's a tricky one to answer. I must confess, it's, yeah, like you've mentioned, all sort of actors involved in the process, and yeah, I'm not sure that I can even answer who should have the final say. It's a tricky one because, you know, we'd like to think parents know what's best for their children, but like you said, in the South African context, that becomes difficult. But I think it's just important to sort of bear in mind that sometimes children know more than we think they know. They may surprise us with their insight as to what's best for them. But yeah, I agree. It becomes difficult when matters then go to the Constitutional Court. Concord then has, you know, obligations and has to think about a particular child in front of them, and it just makes matters messy. So I guess my answer is we need more work on defining this an appropriate scope for best interests of the child. So that's also something for future research. And yeah, thank you about your question on comparative analysis. I haven't done a comparative study, but that is, that would also add value, certainly, in evaluating the strength of our legal framework and not just enforcement. So thanks for that. And on the gender dynamics in the Children's Act. So I think when it comes specifically to protection of children from violence, I think it is then important for a gendered view to be adopted, to acknowledge the disproportionate impact, for specifically in relation to sexual violence against children and on girls, and sort of an argument can be made that this is unnecessary because Sexual Offences Act adopts a gendered view, but because the Children's Act is the primary legislation giving effect to children's international law rights, and it's the first piece of legislation you think of when you think of children and their rights, I think for that reason, it's important for this act to adopt a gendered view. I haven't thought about whether this should be in relation to perpetrators too. I was thinking specifically of victims, so people who are impacted by violence. I think insofar as I can remember, I don't think the Children's Act, insofar as it speaks of perpetrators, I'm not sure if there is a need for any gendered view to be taken there.
Thank you so much, Sapna. Is there anyone who's Wahida?
Yeah, I just want to ask a question about the age of majority. So, you know, the convention places or defines a child as one who is 18 or under. And so our South African Constitution has followed that international definition. What are your thoughts about that particular number being identified as the age at which we distinguish between a child and an adult? Because, I mean, you can argue that it's really quite arbitrary. They could have made it 17, used to be 16. It still is 16 for females in the Marriage Act. And in fact, the Marriage Act, I would argue, is quite discriminatory in distinguishing a male as being capable of marrying at the age of child marriages, etc. arise. But I'm interested to know if you've given some thought to that number 18. You know, where did it originate? And is it a number that still makes sense in our current context?
I'll just ask questions following Wahida's question related actually. Also, I'm thinking based on that, does the law says anything about violence against children by children, and also the age? Because you find out that young people, they're perpetrators of violence, and especially when you look at the marginalized communities. And also, as we're looking at violence against children, did you look at in the South African context in general, or did you look at specific areas where the violence is prevalent, like where there's more violence, or just South African context in general?
Thank you. Yeah, thank you both for your questions. The question on the age of majority is an interesting one, and it is sort of, you know, it's a contentious one and can definitely be debated. I think that the number 18 comes from developmental research, and I'm not too clued up on this, but I think it's to do with sort of child's development and development of the brain. You know, when children are adolescents, their like prefrontal cortex is still developing and changing. So I think that's where the number comes from. Now, what's interesting is, like you say, that could be an arbitrary number. I think the reason that, you know, the number 18 rather than 16 is adopted is to ensure that children receive protection of the law right up until they're 18. So allow them to be protected as children for as long as possible. But then the other side of the coin is that, you know, they might be an adult actually at 16 or 17, but now we're treating them like a child, and there's other rights that only become available at the age of majority. So for example, the right to vote, you know, it might make more sense for children age 16 to be allowed to vote, but because we use the age of majority 18 as sort of a consistent standard, it makes things a bit difficult. So we could argue that, you know, maybe we shouldn't have one consistent standard of a majority age of 18. And I agree, the Marriage Act, you know, that is definitely something that needs to be, you know, spoken about or challenged, because definitely has discriminatory impacts. And yeah. Yeah, thank you, Sisanda, for your questions. When it comes to violence against children by other children, I didn't look specifically at that. So I think the Child Justice Act governs that. I didn't consider that at all. And I know there's a sort of juvenile offenders get diverted from the ordinary criminal justice system, but I focus primarily on children as victims. Yeah. So yeah, thank you. That's also highlighting future avenues for research. And I just focused on evaluating the legal framework and the domestic legislation and policy. So I didn't focus on any empirical research and groups of children, though that would definitely be important. So I sort of just looked at the legislation as a whole and thought of, you know, children, without looking specifically at cultural context, but also trying to recognize that rights may look differently for different children.
This is a last round of questions. Close. Your hands were up at the same time. Okay, you go ahead. Thank you.
Okay, hello everyone. My name is Natsai and I'm coming from Ilitalabandu. We're an organization that is assisting women and children who have been victims, or we call them survivors of violence, but unfortunately we do get victims, of course. I just wanted to thank you on the comments on participation, especially of children. We still do want to see more children participating, but I'm glad that this is happening, because even when we look at the Amendment Bill of 2020 that is currently underway, we have seen children being also asked to come to Parliament or to even make submissions in terms of this bill on what is going to affect them. So thank you so much for that. But we do still want to see more and more children participating in laws that concern them and things that affect them. So thank you for that.
Thank you so much.
Thank you.
Sorry, I missed the presentation. So maybe you mentioned this, but do you think that we should have a standing children's rights commissioner or office to act as a children's rights advocate, to be a forum for participation, and to actively monitor these issues? taking into account the fact that children are distinct.
Yeah. Okay.
Yes,
Thank you. Yes, so I mentioned in my presentation that many commentators have argued for oversight mechanisms to be available. So something like a child ombudsman. So it would be like you say, something like the children's commissioner to then oversee children's interests and sort of advocate for them and can act as their representative. And yeah, I think that is important, especially when it comes sort of to trying to enforce or uphold children's rights. That could be a very useful mechanism. But again, it's important there also for child participation and, taking cognizance of the child's own views and own thoughts, so that it doesn't become sort of this vertical adult-child relationship.
Thank you so much, Sapna. And I think this was very interesting seminar, and the online audience, no comments.
Very quiet today.
Comments from Oswald Brady to say that he also agrees that we need a child rights office.
On that note, I would like to thank everyone at the Center for Criminology for joining us on this seminar series with Sapna, which was very lovely. And we hope to see you next year, right, Kelly?
Next year.
Yeah, we'll see you next year. And thank you, your presence will really, we appreciate them. And to the online audience, Annie. And yes, have a wonderful weekend. It's the start of the weekend already, right? Thank you so much, everyone. Thank you so much.